Hello, and thank you for tuning in. As you know from previous videos, I'm Matthew Pospisil, and I'm an attorney here at Parnham & Associates. And today we're going to be talking about inchoate offenses. Now, like many of you out there, you're probably wondering, what the heck is an inchoate offense? Well, inchoate is just a fancy way of saying basically unprepared or undeveloped crime. A very common example of this are like attempted crimes or conspiracies to commit the crime. For an attempt to commit the crime, the state would have to prove against you that you, A, wanted the crime to happen, you intended to commit that crime, but due to unforeseen circumstances, that crime was not able to be effected. A very common example of this would be something like, let's say me and George are talking about getting ready for a trial. George gets upset with me because I haven't been doing my share of the work or something of that sort. He pulls out a gun, points it at me, pulls the trigger, but the gun jams. Thankfully, I survive, I'm not dead. George at this point in time had attempted to commit the murder of me. By pulling out the gun and pulling the trigger, he's attempting to kill me, but because that gun jammed, that crime was not able to be effected. Therefore, he attempted the crime itself. Now, the way an attempt or inchoate offenses work with the crime is it lowers the punishment down one range of punishment. So in the example I gave with me and George, he was attempting to commit murder. Murder in the first degree is a first-degree felony, which has a range of punishment from 5 years to life in prison. Because he attempted the crime, it's going to drop it down to a second-degree felony, which would have the range of punishment from 2 years to 20 years in prison. Another common inchoate offense is going to be a conspiracy to commit the crime. Now, a conspiracy is going to happen when 2 or more people have an agreement to commit that crime, and then an overt act is being taken in furtherance of that crime. Now, an overt act can be an innocent act, but it infers the actual criminal activity. So to give another example of this, let's say George and Mary are really upset with me as their associate attorney. I'm not doing any work around here. They want me out of the picture. I'm taking too much money from them. So let's say George and Mary have a conversation outside my presence and decide they're going to plan to kill me, to get me out of the picture. Them forming that agreement right there is going to be the start of that conspiracy. Just the talk and communication alone will not be enough, though, because it's going to require that overt act to actually go forward on the conspiracy. So them having the conversation, the agreements, and then if, let's say, George then goes out and purchases a gun. Buying a gun, of course, is an innocent act by itself, but given the scenario and the circumstances, it can be inferred that he's buying that gun in furtherance of going forward with this crime. At this point in time, the police could get involved, and George could be tried on a case for conspiracy to commit murder. And again, just like the other attempted offense, this will drop it down to a second-degree felony instead of a first degree, with a range of punishment from 2 to 20. Another common scheme is going to be criminal solicitation. A person is guilty of criminal solicitation if they attempt to command, induce, or somehow coerce another person to commit that crime for them. So using the prior example of conspiracy, let's say George and Mary get together and decide they don't want to get their hands dirty with this, so they want to try and find somebody else to take me out instead. Let's say they get on the phone and make a call with a number they found on Craigslist to try and hire somebody to come and kill me instead. They make an agreement to go forward, offer some money, and they have some person who then says, yeah, I'll go forward and kill him. At this point in time, they're going forward to try and hire somebody. They're inducing, they're coercing, they're offering cooperation to go forward to try and get me off the picture and kill me. At this point in time, they've committed a criminal solicitation of capital murder. Now, capital murder is going to be a capital offense, which does carry the range of punishment from 5 to life, or the death penalty could be C. Now, because of course it's an inchoate, it's going to drop it back down to the first degree offense, which has the range of punishment from 5 to life. It's going to also be important to note that with a criminal solicitation charge, a person cannot be found guilty unless the testimony being offered is also corroborated by some kind of evidence that actually is furtherance of that issue. So just because, let's say, the hitman goes forward to the police and says, yeah, George and Mary wanted me to kill them, his testimony and his statement would have to be corroborated by some other type of evidence in order for George and Mary to be found guilty. Now, with these inchoate offenses, one of the most common defenses is going to be the renunciation defense. Renunciation is just a fancy way of saying pulling out or trying to avoid what was going to be happening. Now, it's important to note that in order for the renunciation defense to actually be applicable, the person has to actually take the active steps to try and impede the criminal activity from happening. So using the last example we just had with the criminal solicitation, George and Mary hired the hitman who was going to go forward to try and kill me. In order for George and Mary to be able to use the renunciation defense, they would need to try and get law enforcement involved to try and prevent and actually impede the commission of that crime. Them sitting back and saying, I don't want any part of this anymore, would not be enough. They would need to actually take active steps to try and stop the crime from happening itself. Thank you for tuning in. Hope it's been educational.